Landlords lose an average of $2,400 per disputed security deposit, and most of the time they are charging for normal wear and tear that the law says they should cover themselves. This isn't just a minor accounting issue. According to the National Apartment Association's 2023 survey, approximately 43% of security deposit disputes stem from landlords incorrectly categorizing normal wear and tear as tenant damage. That means hundreds of thousands of property owners across the country are exposing themselves to legal liability, tenant disputes, and financial losses every single year. Welcome back to Brick and Dollar Research. Today we're breaking down one of the most expensive misclassifications in property investing, and more importantly, we're showing you exactly how to avoid it. Let's start with the fundamentals. Normal wear and tear is defined as the expected deterioration of a rental property that occurs during normal occupancy, even with proper care from the tenant. This is the landlord's responsibility to cover. Tenant damage, on the other hand, is deterioration that results from negligence, misuse, or lack of ordinary care from the tenant. This is what you can legally deduct from a security deposit. The problem is that these definitions are surprisingly subjective, and state laws vary dramatically. In California, the law is relatively tenant-friendly, while Texas and Florida offer landlords broader deduction rights. This legal patchwork creates confusion, and confusion costs money. Let's look at a specific case study. In 2022, a landlord in Los Angeles charged a tenant $800 for carpet stains and worn carpet fibers. The tenant disputed the charge and won in small claims court. The judge ruled that the carpet, which was 5 years old and had normal wear throughout, fell under normal wear and tear. The landlord not only lost the $800 deduction, but also had to pay the tenant's court filing fees of $185 and lost time. But here's what really hurt. The case went public through the tenant's online review, damaging the landlord's reputation and making it harder to attract quality tenants in the future. This scenario plays out thousands of times annually. According to a 2023 analysis by the American Property Management Association, the average cost of a disputed security deposit case, including court fees, attorney consultation, and lost productivity, exceeds $2,400. When you multiply that by the average landlord managing 3 to 5 properties, you're looking at potential losses of $7,200 to $12,000 annually from just this one issue. So what exactly falls under normal wear and tear? Let's break this down into specific categories with concrete examples. First, flooring. This is where the majority of disputes occur. Normal wear and tear on carpet includes fading from sunlight, slight discoloration from regular foot traffic, and minor matting in high-traffic areas. One Denver property owner charged a tenant $200 to replace carpet that had visible wear patterns from foot traffic. The tenant successfully disputed this in small claims court, citing that the carpet was installed 8 years prior and the wear was consistent with normal use. The landlord lost the full amount plus court costs. Conversely, if a tenant burns a hole in the carpet, stains it with bleach, or creates permanent discoloration from spilled paint, that's tenant damage. Similarly, scratches on hardwood floors from normal furniture movement are wear and tear. Deep gouges, missing sections, or water damage that warps the floor are tenant damage. Second, walls and paint. This is another high dispute category. Normal wear and tear includes scuffs on walls from furniture movement, small nail holes from hanging pictures, minor fading of paint from sunlight, and dirt marks from normal use. However, and this is critical, many state laws include something called the one-coat rule. If a wall simply needs repainting but hasn't been painted in several years, that's maintenance, not a deduction. A property manager in Austin, Texas made this exact mistake, charging a tenant $600 for interior repainting after a 3-year tenancy. The tenant disputed it, and the landlord lost because Texas law considers interior repainting a maintenance expense unless there's actual damage beyond normal wear. Tenant damage with walls includes large holes, permanent stains, damage from negligence, or multiple damaged areas requiring wall repair or drywall replacement. Third, appliances. Normal wear and tear on appliances means they work but may show signs of age. The refrigerator has minor scratches. The stove burners are slightly discolored. However, if an appliance simply stops functioning after normal use, that's typically the landlord's responsibility, not the tenant's damage charge. A Fort Worth landlord charged a tenant $450 for a non-functioning dishwasher after a 2-year tenancy. The tenant objected, pointing out that dishwashers have a typical lifespan of 8 to 10 years. The landlord's attempt to recover the cost failed because the appliance failed due to age, not negligence. Tenant damage would be if the tenant spilled something corrosive into the dishwasher, mechanically damaged the unit, or deliberately broke it. Fourth, fixtures and hardware. Normal wear and tear includes fading on light fixtures, loose cabinet handles from normal use, and minor rust on older hardware. One Miami landlord attempted to charge a tenant $300 for replacing cabinet hardware that was worn out looking. The tenant successfully argued that worn-looking hardware was normal after 3 years of use, and the charge was denied. Tenant damage would be broken cabinet doors, missing handles that were torn off, or deliberately scratched or dented fixtures. Now, let's talk about the financial mechanics of getting this wrong. According to research from the Property Management Center, landlords who dispute security deposit claims without strong documentation lose approximately 71% of those disputes. The cost isn't just the initial deduction amount either. Court filing fees range from $100 to $500 depending on the jurisdiction. If you need an attorney, even a brief consultation costs $150 to $300. Many landlords also need to hire a professional appraiser or photographer to document damage, which adds another $200 to $400. But there's a hidden cost that's even more damaging: legal penalties. Many states impose significant fines if a landlord is found to have wrongfully withheld security deposits. California imposes penalties of up to 3 times the wrongfully withheld amount. New York allows tenants to recover double the wrongfully withheld amount plus attorney fees. Texas adds interest to any wrongfully withheld amount. These penalty structures mean that a $500 mistake in California could cost you $500, and in New York, you might owe $1,000 plus legal fees. Let's examine another case study to illustrate this. A landlord in Brooklyn charged a tenant $100 for carpet replacement, claiming heavy stains. The tenant disputed it and hired a tenants' rights organization to represent her. The court found that the stains were minor and the carpet was 8 years old. Under New York law, the landlord was ordered to return $100 plus an equal penalty of $100, plus the tenant's legal fees of $600. Total cost $800 from a $100 dispute. Here's what separates landlords who win disputes from those who lose them: documentation. The most successful property managers photograph the unit before the tenant moves in and immediately after they move out with timestamp evidence. They document the condition of every major system: flooring, walls, appliances, fixtures, with detailed photos. They also keep records of the property's age, previous maintenance, and the condition of comparable units in the same building. One property management company in Denver implemented a comprehensive photo and video documentation system for all units, cataloging conditions at move-in and move-out. Their security deposit dispute rate dropped from 31% to 8% within 1 year, and they won 94% of the disputes they did face in small claims court. The documentation proved invaluable in demonstrating what was normal wear versus actual damage. Another critical factor is understanding local law. Property managers who invest time in understanding their state's specific definitions and legal standards avoid disputes 66% more often than those who use generic policies. For instance, Maryland law specifically states that carpet is expected to be replaced every 7 years as normal maintenance, which changes how you evaluate carpet conditions. Illinois requires landlords to provide photographic evidence of damage. Florida allows broader deductions but requires itemization within 30 days. Knowing these specifics prevents costly mistakes. So how do you build a system to avoid these expensive misclassifications? First, create a detailed move-in inspection checklist that covers every room, every wall, every fixture, and every appliance. Use this consistently for every tenant. Second, photograph everything. Use professional photos with dates and descriptions. Third, establish clear tenant communication about what they're responsible for and what you maintain. Fourth, hire a professional inspector if disputes occur. Their testimony carries weight in court. Finally, consider the opportunity cost of getting this wrong. The time spent dealing with disputes, responding to tenant complaints, potentially appearing in small claims court, and managing reputation damage is time you're not spending on growing your business or acquiring new properties. For many landlords, the real cost of a $400 security deposit dispute isn't the $400, it's the 10 to 15 hours of work and the stress involved in resolving it. The bottom line: understand the legal definitions in your jurisdiction,